You do not want to scroll past this. The Department of Justice just did something nobody expected. It sued Los Angeles County, not over police brutality, not over civil service corruption, but for allegedly weaponizing bureaucracy to deny law-abiding residents their right to carry a firearm for self-defense. That's right, the federal government invoked its civil rights enforcement powers to say that long waits and endless paperwork are not merely incompetence, they can be a constitutional violation. If you care about rights, law, or how governments can quietly restrict them, this story is massive. Welcome back to the channel. If this is your first time here, do me a favor. Hit subscribe, ring that bell, and like this video so YouTube actually shows this to people who need to see it. Today we're unpacking what the DOJ filed, why they used a civil rights statute instead of a straight Second Amendment suit, the jaw-dropping numbers, what this could mean for other counties and states, and what to watch for next. I'll break it down in plain English and tell you the 3 things every gun owner and concerned citizen should do right now. What happened? Plain and simple. Late last month, the Justice Department's Civil Rights Division filed an affirmative lawsuit against the Los Angeles County Sheriff's Department, claiming a pattern or practice of delaying concealed carry applications so severely that the delays functionally deny people their right to bear arms outside the home. This isn't a paper complaint about a backlog. The DOJ alleges the delays are systematic and long-standing, and it asked a federal court to order LA County to process permits within the timeframes required by California law and to accept federal oversight to make sure it stops. The numbers that make the complaint shocking. The figures the DOJ sets out are the kind of stats that change headlines. Between January 2024 and March 2025, the complaint says LA County received roughly 3,982 new applications for concealed carry permits, and only 2 were approved in that window. The DOJ reports applicants waited an average of 9 months just to have the county begin processing their file, and some people waited more than 2 or even nearly 3 years to get an interview. Those timelines dwarf California's statutory expectation, which envisions initial processing in the order of months, not years. If those numbers are borne out at trial, they make the DOJ's case look very strong. Why the DOJ used civil rights law, not the usual route? This is the clever bit. Instead of filing a classic Second Amendment lawsuit, the DOJ relied on its pattern or practice authority under federal civil rights statutes. The same tool historically used to remedy police departments that engage in systemic racial profiling or unconstitutional uses of force. The theory is straightforward. If a government office uses delay and administrative bottlenecks to prevent citizens from exercising a constitutional right, that can be viewed as a systemic denial of that right. Using this framework gives the DOJ different remedies, including court-ordered monitoring and sweeping structural changes, not just a declaratory judgment. That's a legal pivot that could change enforcement strategy nationwide. Context: why this matters after the Supreme Court's major rulings. Remember the Supreme Court's decisions over the last few years that reshaped how courts review gun rules? After those rulings, certain jurisdictions abandoned blunt legal barriers and instead relied on administrative workarounds, making it technically lawful on paper while making access practically impossible through months or years of delay. The DOJ's case directly targets that bypass. You can't hide a de facto restriction behind paperwork and call it compliance. If courts accept that logic, an administrative tactic that's been used to limit rights without changing the law becomes a federal problem. LA County's response: understaffing and system overhaul claims. LA officials and the Sheriff's Department dispute the DOJ's portrayal. The county says it has struggled with a legacy paper-based system, staffing shortages, and the massive surge of applications that followed major court rulings. The Sheriff's Office points to progress in processing rates in recent months and says it has approved thousands of permits over several years. Those facts will be central to the defense. Is this an operational bottleneck caused by change and resource limits, or is it a deliberate administrative chokehold? The court will have to parse those competing narratives. How the DOJ proves a pattern or practice, what they'll need to show. To win a pattern or practice case, the DOJ won't just point to a few bad files. It must show systemic behavior. That means looking for internal communications, policies, email chains, staffing memos, deviation from normal timelines, and comparative data from other counties. The DOJ will also use applicant testimony, people who can show a trail of missed interviews and unexplained delays. If the evidence shows repeated internal decisions or consistent practices that produce extreme delay, the DOJ can demonstrate that the delays aren't random but part of a system that denies constitutional rights. Why other counties and states should be nervous. If a federal court accepts the DOJ's argument, the consequences ripple. Any county that has used subjective criteria, good cause screens, or simply kept people in an indefinite queue could now face federal scrutiny. That's especially important in states that have historically made permitting difficult by statute and in practice. The DOJ's move essentially says, if you're avoiding constitutional limits by administrative trickery, expect the federal government to treat that as a civil rights violation. That could force faster processing, clearer criteria, and possibly federal monitoring in jurisdictions found to be out of compliance. What a win by the DOJ could look like. If the DOJ prevails, a federal judge could order LA County to meet clear deadlines, adopt transparent procedures, and allow federal oversight. Maybe even appoint a monitor to make sure the department follows through. It wouldn't just be a one-off fix. It could establish legal precedent that administrative delay, when used systematically, violates constitutional protections. Practically speaking, that could open the door to lawsuits or investigations in places that have long used slow processing to suppress access to permits. What a DOJ loss could mean. If the county stops the DOJ, the message is different. The court could find that delays were attributable to resource constraints or chaotic transitions rather than discriminatory intent or systemic practice. A loss might embolden other jurisdictions to double down on administrative hurdles instead of changing laws. Either way, a ruling one way or another will clarify the reach of civil rights enforcement tools when applied to gun permit systems. The politics and optics. Yes, it's political, but the legal question is institutional. Make no mistake, this case lands in a political landscape. The federal government suing a major blue county over a right many associate with conservative politics will be framed differently by different outlets. Critics will say it's partisan enforcement. Supporters will say it's constitutional fidelity. But beyond politics, the central question is institutional. Does the Constitution protect access to a right in practice as well as on paper? The DOJ's stance is institutional. Rights must be enforceable. That's the core legal argument driving this suit. What applicants and gun owners should do now. If you've applied for a permit in LA County or a similar jurisdiction and you're stuck in limbo, start documenting everything. Save emails, record dates of interviews, note canceled appointments, and keep copies of any correspondence. Those records matter in pattern or practice cases. Also, follow the court docket closely. If the DOJ obtains preliminary relief, it could change immediate timelines and grant workarounds for applicants in the near term. For the rest of us, stay informed. This case could affect how quickly and easily people can exercise a constitutional right nationwide. 3 practical things citizens can do. First, subscribe to reliable court reporting outlets and the court docket for this case. The filings themselves tell the story. Second, if you're in a county with long permit waits and you think you have evidence, contact local advocacy or legal groups. Patterns are proven with many individual stories aggregated. Third, engage civically. Contact your local supervisors and demand transparency about permit processing times and staffing. And ask how funds are being allocated to meet legal obligations. How the media and interest groups are responding. Right now, interest groups are lining up on both sides. Gun rights organizations hail the DOJ move as a long overdue enforcement of constitutional protections, while gun safety and civil rights advocates have raised concerns about diverting the DOJ's civil rights machinery away from traditional focuses like policing abuses. Media coverage is split. with national outlets emphasizing the legal novelty and local outlets digging into the data and county explanations. Expect amicus briefs and high-profile commentary as the case progresses. What judges will look at when deciding? Judges will focus on whether the delays rise to an actionable constitutional wrong. That means examining the scale and duration of delays, internal reasons for them, comparisons with peer counties, and whether applicants were singled out or systematically affected. Expect detailed discovery, depositions of county supervisors, and a heavy reliance on empirical evidence. A judge could be persuaded by a comprehensive showing that the county's practices consistently produce unconstitutional results. Potential timeline and court mechanics. This will not be a lightning case. Pattern or practice litigation takes time. Investigations, discovery, motions for injunctive relief, and possibly a trial. That said, the DOJ may seek quick interim orders if it can show irreparable harm. People waiting years to exercise a right could justify a faster remedy. Meanwhile, appeals are likely if the district court issues sweeping remedial orders. Put another way, the litigation could reshape practice for years. Why this is a legal and cultural hinge point. What's happening here is bigger than one county's bureaucracy. It's a test of whether constitutional rights are meaningful in practice or merely aspirational on paper. The DOJ's strategy, using civil rights enforcement to challenge administrative obstruction, could either expand federal tools to protect rights or provoke a pushback that narrows those tools. Either outcome will matter for how rights are enforced in the U.S. All right, what do you think? Is this federal overreach or necessary enforcement? Have you or someone you know been stuck in an absurd permit backlog? Drop your experience in the comments. Real stories matter. If you want me to keep following this case closely and to do a deep legal breakdown of the DOJ's filings and possible remedies, say so in the comments and I'll post follow-ups. And again, if you're new here, subscribe, smash the like button, and share this video with anyone who's been on a permit waitlist. Your engagement helps this channel stay on top of stories like this. We're watching a moment where the federal government tried something novel, to treat administrative delay as a civil rights problem. That's a bold argument with enormous stakes for rights, governance, and local accountability. This is Act 1. The courtroom drama has only begun. Keep your eyes on the docket, and I'll keep you informed.